Welcome to the debate.
Today, we're diving immediately into the political shockwave that's hit Washington. This all follows the former president's controversial statements suggesting, and I'm quoting here, that massive election fraud allows for the termination of all rules, regulations, and articles, even those found in the Constitution.
Right, and that led to the fastest introduction of new articles of impeachment we have ever seen, really targeting the relationship between the executive and, the foundational document itself.
So this speed and the substance of it all, it forces a really crucial question, the one we're here to discuss. Does this conflict, triggered by these remarks about terminating constitutional provisions, does this constitute an unprecedented constitutional crisis? Or is it just a predictable escalation of politics as usual, operating entirely within the system's normal, if strenuous, parameters?
The nature of these statements? Well, it pushes us squarely into an unprecedented crisis. When a former president suggests the supreme law of the land can simply be dissolved, we've crossed an existential red line that previous conflicts, even high-stakes impeachments, just never approached.
And I come at it from a different way. While the rhetoric is, I agree, undeniably extreme and provocative, the institutional responses, how Congress and the political parties are reacting, are entirely predictable. To me, the system is functioning, albeit loudly and strenuously. This predictability suggests this is intense partisan warfare, meaning it's still politics as usual, not some kind of systemic breakdown.
I see why you'd think that, especially given the history of the previous impeachments. But this is fundamentally different because it targets the Constitution itself, not just alleged abuses of power under it. The Democrats' rationale for rushing these papers, that the president is undermining the very framework that holds this country together, that demonstrates a perceived existential threat. And just think about the response. Impeachment papers were rushed in hours, and, massive protests mobilized nationwide within days. That reaction, and even the harsh condemnation from within the president's own party, calling the statements un-American, well, that signals a perceived breach of constitutional norms that far transcends normal political rivalry.
That's a compelling argument based on, let's say, rhetoric and emotional response. But I think we have to look at the institutional dynamics. If the system were truly broken, we wouldn't be seeing Congress utilizing the exact constitutional and parliamentary tools that are designed for these high-stakes conflicts. The mechanisms being used are frankly a rerun of previous political fights. The House may pass the articles, sure, but the Senate is almost certain to acquit. That's consistent with the two previous impeachments. The senator's political incentive is clear: stay with the president to avoid primary challenges. So where is the evidence that the final resolving outcome will be anything but intensely political rather than constitutional?
Well, I have to challenge your assertion that this is routine simply because the procedure being used is standard. How can an explicit statement about the termination of constitutional articles be characterized as anything less than an existential attack on the rule of law? It's the precedent this sets that destabilizes the future. By normalizing this kind of rhetoric, the idea that the Constitution's supremacy is somehow debatable, it poses a high-level threat to future constitutional stability, regardless of what the immediate political outcome is.
I'm just not convinced by that line of reasoning. Because the political system has effectively, let's say it's exhausted the political power of impeachment. Let me give you a different perspective. Because this is the third impeachment process. The frequency itself structurally weakens the tool. It starts to look like a predictable political tactic that loses moral and constitutional weight for the public, regardless of the severity of the offense being debated. You can argue the rhetoric is an existential threat, but if the primary constitutional accountability tool, impeachment, is weakened by repetition, then the system has created its own neutralizing mechanism, which just reinforces the politics as usual label.
And that brings us directly to how Congress is choosing to fight back. If this is just politics, the use of the privileged resolution certainly seems to prove your point. You mentioned it forces a vote. Can you elaborate on why this procedural mechanism is such a powerful political weapon right now?
Absolutely. The use of the privileged resolution is, yes, it's highly effective, but it's standard parliamentary warfare. Crucially, it bypasses the committee system where leadership could otherwise just let the motion die quietly. It forces every House member, especially vulnerable Republicans, on the record immediately ahead of the 2026 midterms. This is a deliberate, tactical move designed to generate electoral advantage and internal division for the opposition. So yes, this is proof that the central actors are operating with electoral strategy, which is the very definition of politics as usual.
That's an interesting point about the tactic, though I would frame it differently. The need for such extreme procedural maneuvering, bypassing leadership and forcing a floor vote, it actually demonstrates the gravity of the underlying constitutional issue. The issue is deemed too serious to be managed through normal legislative compromise. The fact that this specific procedural bomb is being deployed for an attack on the constitutional framework itself, rather than, say, a budget squabble, that signifies a profound crisis moment in legislative accountability.
I think I have to reiterate the judicial restraint we've seen. Many constitutional experts who reject the crisis label, they argue this only becomes a true breakdown when the president moves beyond rhetoric to concrete action. The courts have established boundaries, relying on doctrines like ripeness and standing. They require specific, concrete harm from an implemented policy, not just inflammatory speech. Courts have historically stayed out of these so-called political questions, reserving their intervention for actual implemented executive actions that violate the Constitution, like we saw with previous actions on immigration or military funding. So until there is policy implementation based on this termination logic, the courts will not intervene. And that shows the system has defined mechanisms for staying out of mere political conflict.
I acknowledge that courts may wait for executive action. I do. However, the collision of major institutions, a president challenging constitutional supremacy, Congress pursuing accountability through emergency mechanisms, and a divided public demanding action, that, combined with the resulting lack of a clear institutional resolution in sight, is precisely what defines a constitutional crisis. The damage to the Constitution's authority has already occurred by making its supremacy subject to political debate, and the judiciary's decision to stand down for now, it only highlights the severity of the institutional vacuum this conflict has created. I don't think we can afford to wait for policy implementation when the foundational legal authority has been so explicitly questioned.
So my position remains that the substantive nature of the threat attacking the Constitution's supremacy and the rapid nationwide institutional reaction, that is what distinguishes this situation from anything we have seen before. This tests the very boundaries of American governance, and it sets a dangerous new precedent regarding executive restraint, moving us into an unprecedented constitutional crisis.
And my counterposition is that while the rhetoric is exhausting and, yes, alarming, the institutional response follows predictable patterns. The weakening of the impeachment tool through its high-volume usage, the calculated political maneuvering via parliamentary strategy, and the predictable Senate acquittal all show that this conflict, however intense, remains firmly within the bounds of intense partisan politics driven by electoral strategy.
I think the material provides vital insights into two parallel strains on the American system. You have this high-stakes threat posed by rhetoric that undermines constitutional authority, and at the same time, the structural exhaustion of the very tools designed to handle that threat.
Indeed, the eventual resolution, whether the courts are forced to intervene or if the political system merely absorbs and normalizes this level of constitutional challenge, that will ultimately determine if this period is remembered as a dangerous political storm or a fundamental constitutional breakdown. There is certainly much more to explore in the material regarding these twin precedents.